talk about issues and red flags.
This meeting is being recorded.
Sorry. I just hit record. Sorry about that.
That's okay. We're going to look at things that should cause you to stop and make a phone call and discuss with your escrow officer items of concern. So Lynette is going to put up the presentation. We have a sample preliminary report to review, and we're just going to break it down page by page of what you should expect to see when you order a preliminary title report from First American Title. Remember, first and foremost, First American Title is an insurance company. We are insuring a transaction. We're insuring your buyer that they actually own the property that they're buying, free from encumbrances, liens, judgments, and we're ensuring that we have found all of the sellers that might have an interest in the property and made sure that they are relinquishing that interest in our transaction. That's the whole purpose of opening an escrow and having First American handle your transaction. We want to protect your buyers that they buy a property and know that they really own it. And remember, the title insurance policy covers the buyer for as long as they own the property. They pay it one time in escrow and it covers them until they sell the property. So it could be forever if that's how long they end up owning the property.
Let's see, Lynette, have you, can you
Can
share
you see my,
no,
you see my screen?
Nope.
Oh,
Can
here I'm
anyone
like
else see
going.
it?
Okay, so let me see. Share. Sorry, I'm like going back
There
and
we
forth thinking, how come you're not telling me next? I'm not a bit too
Thank
far. Is that what you want, Les?
No, you can go back to the first. Let me just see those topics, make sure I covered everything. Let's go back.
So there's Team
There's
Sonoma.
the sales team. Next. There's me. I'm at the First American Santa Rosa, Maine office. I am the North Bay Regional Trainer and Escrow Officer. I'm happy to answer questions, even if your deal hasn't come together yet. If you have questions, need some help, I'm absolutely happy to help you with that. So feel free to reach out. If you ever have any questions, ask me, ask the sales team. We are here to help. Next slide. I have to read our disclaimer. The following presentation is for informational purposes only and is not and may not be construed as legal advice. I'm not an attorney, so I'm not giving any kind of advice. First American Title Insurance Company is not a law firm and does not offer legal services of any kind. No third-party entity may rely upon anything contained herein when making legal and/or other determinations regarding title practices. You should consult with an attorney prior to embarking on any specific course of action. Next slide. So here we are. What is a preliminary report? What is a preliminary report versus title insurance? Some vocabulary, how to review it, and again, the red flags. When I am working with new escrow officers, assistants, when I'm giving this class, I use the analogy, I want those red flags to jump off of the page at you. So I want to show you some things that you might see on a report that should really cause for a moment to go, okay, what is this? Wait a minute, how do we deal with this? Next slide. So as I said before, a preliminary report is an informational report that we put out when you open a transaction. We'll show the current vesting, the current owners, the legal description, any liens and encumbrances, any easements. And it is our commitment that we will insure the property subject to the matters that we show on the report. So the report basically says, yes, we're willing to insure this property, except for these items we won't cover. And typically it's things that are on the record that we know about, and we're not going to cover any liens or claims against them because we know they're on the record. Now, that being said, there are things that can come off the pre-limit closing, like an existing mortgage that gets paid off as part of the transaction. It is not an abstract title, so it isn't everything that's ever been recorded. It's not a chain of title. It's only a snapshot of First American Title saying we're ready to insure this property except for what we show. Next slide. A preliminary report is not title insurance. When we put out a prelim, we are not issuing a policy. We have to close the transaction to issue a policy. So it's not a representation that it is a policy. If you get a prelim from us, it doesn't mean that you're insured. It just means that we're showing you the exceptions to the matters that we would and would not insure. The purpose of it, of course, is for your buyer to see what's recorded against the property that they're buying, to see if it's something they can accept, if it's something that they're interested in taking on. Sometimes it's not if it has easements in a certain place. The biggest example is an easement going through the backyard that would prevent them from putting in a swimming pool. That's what the prelim is for, to let them do some due diligence to see if this property really is what they want to buy. Next slide. At the back of our preliminary report, we always include several pages of what we call our Western regional exceptions and our privacy policy. And these are the detailed legal language of what coverage we offer and what coverage we don't offer. Next slide. Looks like we can keep going. Let's go to the next slide. So here we are, we're going to review a sample preliminary report and give you an idea of what to expect when you get a preliminary report from us. Next slide. So the first page of our report has just informational items to look at. It's got our order number, it's got the escrow officer, it's got the seller, the property address. It's got information of who's involved in this transaction. Just a side note, if something is misspelled on this first page, it doesn't necessarily mean that it's misspelled of the public record. It's just that the information in our file maybe got jumbled. So if you get a prelim and this first page has typos, let us know. We can fix it for you. Or we can take a look and make sure that it's not something that is of the record. Those paragraphs under sample preliminary report are the language that I was talking to earlier about. We're giving this report as a representation to issue a policy of title insurance upon successful closing of a transaction. Next slide. The first thing you will see always in our report is a date. And this one's dated as of August 30th, 2020. That date will never be today's date. That date is the date that the information we show on the prelim is available in the county records, whatever county the property is in. And typically the county record database, where we can actually look at documents that are recorded, is 10 days behind, always. So that date is known as the plant date, meaning as of that date, documents are available to be viewed from the county records. The county takes that 10-day period from when you record something to index the recorded documents, post them to the correct property, and put them, it used to be on microfilm, but now it's electronic, but put the copies of the documents available to the public to be viewed. And they're always 10 days behind. Every once in a while, we'll have someone ask us to date the prelim as of today's date, and we're not able to because they're always, like I said, it's typically a week to 10 days behind. The next item is the type of policy that we're in preparation of issuing, whether it's a homeowner's policy or what's commonly known as our Eagle owner's policy, or the loan policy, or the standard Alta policy, depending on the type of property. The purple arrow is pointing to the vesting. This is how the seller holds title to the property. Looks like it's Betty Smith, a married woman, as her sole and separate property. The only owner is Betty. One of the things I do as an escrow officer is I look at the contract. Who signed the contract? Who's on the prelim? If John Jones signed the contract as the seller, but I see Betty Smith in title, I want to know, where's Betty and why didn't she sign the contract? She's holding title as an individual. This property would have to go through probate before we can close a transaction. And I actually had a transaction, all cash, 7-day close, where once we had the preliminary report, they neglected to tell us, the seller side didn't tell us, hey, we have to go through probate and we haven't even started it yet. So that transaction took a little bit longer because we had to deal with probate. If Betty is alive and well, yay, we're happy. Moving on. The next item shows what type of property we're dealing with, and typically real estate is held in fee. That means you own the land. California does not have leasehold interests like Hawaii, so you own the land. I'm going to skip ahead to the teal exception, the teal and orange 6 and 7. This says as of the date above, which is, remember, the plant date, here's what we find. And the first thing we find is always taxes. The government is always first in line, no matter what. Taxes are always a lien against the property. It's just whether or not they're due or payable. And if you look at that first exception, it says for the tax year 20 to 21, a lien not yet due or payable. And all that means is that the county has not put out the tax bills yet. You can't pay those taxes until they do put out the tax bill. But taxes are always first in line. Government always has their hand out first. The next exception shows some supplemental taxes. So these owners bought the property recent enough that they have a supplemental bill that are delinquent. And we get this question from a buyer. Well, does the buyer have to pay those? No. We charge the seller out of their proceeds and pay any defaulted, delinquent, or due taxes so that your buyer starts out with a clean slate as far as the taxes go when they buy the property. They should not be responsible for taxes that were due before their ownership. So that's part of what escrow does as part of the transaction. Next slide. We always put in a paragraph. Remember, taxes are always a lien. Taxes are always a lien. We always include a paragraph that says a lien of supplemental taxes, if any, because we cannot guarantee in the future that this property won't be assessed with a supplemental bill. And if you have a buyer, they will be assessed with a supplemental bill. Supplemental bills are taking 8 to 10 months, even longer, to be assessed. The county got behind with the fires and then stayed behind with COVID. So your buyer buying now may not see a supplemental bill until the middle of next spring. And that's the catch up between the taxes that the seller pays and what the buyer would pay based on their purchase price. There are covenants and restrictions, affectionately known as CC&Rs. And in this case, we don't see that there's a homeowners association. So there are those rules, the subdivision rules, to keep people from being a nuisance in a residential neighborhood, but there's no one to monitor, there's no dues. So they just stay there. If they were to be enforced, it would typically be enforced by whatever the city health and safety codes would be, because without a board for someone to go before for their bad behavior, there really isn't a way to handle infractions against the CC&Rs. I have to say that in any county, pretty much anywhere, there are old CC&Rs, old 80 years old, 100 years old, that are discriminatory. Because at the time, that's what they did. And we all know now it's really wrong, but because they're recorded in the public record, they're kind of stuck there. They're permanent. So for the state of California, this year, they've enacted a program where they're going through and redacting, putting those black marks on anything, any language that is discriminatory in all the counties of California. And I think there's 54. So they are taking the time to remove discriminatory language from all of these recorded documents. It's a huge project. I see a question. Is there something you could forward to your clients to CC&Rs? Yes, we provide copies. When you open an escrow, we provide a copy of the CC&R so that they can read through them. Again, please don't be offended if the language is still in there, anything that's discriminatory cannot be enforced. But it is good to know if there's rules around having an RV or a boat, or in my case, in my neighborhood, I can't leave my garage door open for more than 3 hours. Oh, sorry, Chris, I didn't see your prior comment. or Curtis. Lynette or Karen, can you see the chat?
Yep. So is there an easy link to see all the additional endorsements and costs that title companies offer?
Not that I'm aware of. Unless, and cost first.
There
We
are
have-
there are some endorsement fees in there. Yes, you can see those.
But probably not all of them. So we
Right.
might have to look at case by case.
Sure.
I'm sorry, I did not see who asked that question, but are they asking for title and escrow fees? Because we do have some platforms that will show you that.
No, it's more specifically title endorsement fees.
Okay,
Yeah. And for my experience, it may be a case by case. Moving on from the CC&Rs, we have an easement. If there's a question of where that easement is located, and if there's enough information in that recorded document for us to locate it, we can provide a color-coded map that shows where that easement is and how it affects the property. So again, I use the example, and this was a real story. They had a storm drain easement in the backyard that infringed enough on the backyard that it wouldn't fit a swimming pool. And that buyer decided, maybe it's not a good idea for me to buy this property if I want to put in a pool. It's good to know where those easements lie. In a subdivision, they typically lie under the sidewalk, and they like to group the easements together so that you don't have 4 different easements all over the property. The gas and the sewer and the power line are pretty easy to find because of the box. So in my yard, I have like a suitcase sized box on my lawn, and it goes right up to where the electrical panel is and where the gas meter is. So I know that that's where the gas and electrical public utility easements are in my property. Now it's not exact, and I'm not going to go digging without having PG&E mark the lines, but it gives you an idea where that easement would lie. Curtis, can I plot easements when they are only, I don't see the whole question, sorry.
It says, can you plot easements when they are only in meets and bounds?
Sure, as long as the document is specific enough, but sometimes PG&E is famous for it, to have recorded a PG&E easement and not give enough specific information in the recorded document to show exactly where it is. I did have a wisecracking title officer that once said, if you want to know where the PG&E easement is, go out, see the power pole, look up, that's where it is. But for more specific ones, if you need to know where it is, we can only rely on what's recorded. And so we do our best to plot them and put them on a map as long as the recorded document has enough information for us to do so. But even if it's meets and bounds, we can still find it as long as, like I say, it has enough information. It's a good idea if there's a well easement, a sewer easement, it's good to know where those things are, especially in your more rural property. That's the blessing we have in Sonoma County. We're not just urban. We have agricultural, we have urban, we have commercial, we have a whole different type of property. It's not all the same. So if you're getting out there into, say, West County or North County, agricultural property, it's really important that you do know where those easements are, and we're happy to plot them. The next couple of items are deeds of trust. Those are the loans that the seller has. And there's a notice of default. That's a thing I said to jump off the page. If you have a listing and this is your seller, we need to talk, because a notice of default means that the lender has started the foreclosure process, and we need to talk about communicating with the lender, getting a payoff demand, making sure the lender timing isn't going to foreclose before we can close our transaction, because that would unwind everything and be really a mess. So it's good to talk to your escrow officer when you have a listing, when you look at the prelim. Let's talk about the loans that are on the property. Sometimes we'll find old deeds of trust that the seller thought were long gone, long paid off, and we have to do some research into getting rid of them. So it's really important to talk to your seller. Hey, do you have a line of credit? Because it looks like they do. People forget about that. It has a zero balance. It's like that credit card in a drawer I forgot about. It has a zero balance. Lines of credit are tied to the property and need to be paid off at closing. So it's good to have the conversation with your seller. Also, in escrow, we need to get information to pay off those loans or contact the lender to get releases for them. So we need your seller to provide us with the name of their lender, the account number and their social security number so that we can reach out to those lenders. That's how they index loans, is with the account number and social security number. I always appreciate a warm handoff on a listing if you can prepare your seller that we're going to reach out and ask for this information so they're not blindsided, because sometimes I'll get, why do you need this? It's of the record. It is, but your social security number is not, and we'll need that in order to get a payoff. Next slide. This is the notes page. This tells you the previous tax year, whether the taxes are paid or not. This will tell you what type of property we have. In this case, it's a single family residence, but if it's a multifamily, it'll say so. If it's a duplex, if it's vacant land, if it's a commercial property, it will show that in the informational notes. And then we also show the conveyances of the property in the last 24 months. Lenders ask us for that, and we'll show any deed that was recorded that transferred property in the last 24 months. And in this case, we can see that Ivan and Michelle deeded to Betty, and that was recorded a year or so before this prelim was put out. Next slide. Here we have the legal description and the assessor's parcel map. Legal description is the permanent description of where the property sits in either the subdivision map or the parcel map. It's the description of the property. It says where the land is, so it's a unique identifier. Now, every once in a while, I will get a question, because if you look carefully, the legal description shows our lot as lot 20, but the assessor's parcel number, it looks like it ends in a 7. It doesn't matter that I can't read it, but let's just say it ends in 7. I'll get a phone call and says, you have the wrong lot. It's lot 7. Well, no, the 7 is the assessor's parcel number, but the legal description is lot 20 because it's lot 20 of tract 11111 of the map. When the builder developed that subdivision, they had to file a map and record it with the county, and each property got its unique location on that map recorded as a legal description. Sometimes legal description will be like this, lot 20 of Happy Valley subdivision. Sometimes it'll be 6 pages because it's got the therefore the southwest corner, henceforth, that kind of legal description. It just depends on where the property is located. We don't rely on property addresses. We rely on the legal description because the legal description is so much more permanent. It takes a lot more to change a legal description. Sometimes we'll see instances where the post office and the county will disagree on what the addresses are. I had a property like this one. See how it's on the corner of Bel Air and Irwin? Well, it was on the corner of like Winter Wheat and Southwest, and the post office gave it the Winter Wheat address and the county gave it the Southwest address. Which is right? We stay out of that fight by saying, hey, doesn't matter what the address is. We're going to fall back on the legal description. It's a lot more permanent. We're going to talk a little bit about the assessor's parcel map because I get phone calls about them sometimes. It is not meant as a survey map. So there might be measurements or descriptions on the parcel map that aren't quite accurate. It's not meant for that. It's meant to show the tax rate and the tract that the property is in. It's not the same as a survey. And assessor's parcel map have a disclaimer on them that says that. It can give you an idea what the dimensions are, but if you really have to know the specifics of that, we would want to look to see if a survey was done. Sometimes there's a survey map recorded and it'll have the absolute measurements, or buyer would have to go and get a survey done to mark out the dimensions of the property, the boundaries of the property, any easements, any dimensions, what have you. Next slide. I don't know, there's a part of me, I like to talk about this because I want to have people, I think being aware is important. Knowledge is power in my thought process. And anytime you see any of these things, we need to talk. First, we see a mechanic's lien. Well, we need that contractor to either give us notice that debt has been paid, and we would need to record a release for it, or we'd have to pay the contractor if he isn't paid and get him to sign a release. So if you see any kind of claim or lien, a child support lien, a judgment, we may have to pay that. And I have had a seller say, well, I'm not paying him. Well, we can't insure the property unless he releases that interest that he put in place by that lien. So we'd have to work to find some way, maybe they work out some kind of agreement to get that contractor to give us a release to remove that mechanic's lien. There's a quiet title action. That a notice of action is also known as a lis pendens, and it's where if there is a court case going on that's involving this property, they file what's called a lis pendens, and it's just a notice that says this property is under dispute, and it's to keep the property from being transferred or sold or anything happening to it until the dispute is resolved. It's the whole purpose that if it's in dispute, seller can't then get rid of the property and somehow get out from under whatever the conflict is, whatever the court case is. So if there is a lis pendens, we would need to record a withdrawal for it. And I've had that several times. They resolve whatever it is, or they decided not to go forward with the court action and provided us with a withdrawal. If your seller is in bankruptcy, we have to deal with the bankruptcy trustee and the bankruptcy court, and those entities have to give us permission to close, permission of who to pay in the transaction. So bankruptcy is delicate. We need to know right away. And if we see this on our prelim, we're going to be talking right away. Don't expect the fastest close with a bankruptcy, because we're dealing with powers that be that we don't have any control over and have rights in the property because of the bankruptcy. So our timeline is based on what they tell us we can do. Unfortunately, we don't always have control over property that's in bankruptcy. The number 4 item says the effect of a deed. And what that is people can record deeds on a property at any time without a title company. They can transfer the property to whoever they like at any time. If that happens, we would like some assurance that that wasn't done fraudulently. We're looking to protect our seller, our buyer, our transaction, to prove that this person actually had an interest in the property, meant to grant it to who has it now, and we have them sign an affidavit to that effect, and we keep it in our file to show that, yes, this was really a legitimate transfer. It was not done fraudulently, and that way we're mitigating the risk of someone coming forward and having a claim of interest in the property because of a uninsured deed that a title company didn't record. Number 5 is access. If you see the lack of right of access, that's a thing. We need to talk. That means there's no easement to get to the property. Every once in a while, we do have properties that are considered landlocked, and the owner of the property would have to get an easement for access over a neighboring property if it doesn't abut a public street. Lack of right of access needs to be dealt with. That may need to get a real estate attorney involved, a surveyor. We need to take some course of action to get access to and from a public street to the property. Number 6 is a statement of information. And what that is we have access to public record for everyone. And the example I like to use, they use John Smith, but that's pretty obvious. But I went to high school with 3 people named Mike Jones, completely unrelated. If one Mike Jones has a lien against him, but our seller is the other Mike Jones, we need to rule out that that lien isn't against our seller. So we will ask for what's called a statement of information. Sometimes we come up against a little bit of pushback because it seems invasive, because it asks, when were you born? Where were you born? Who are you married to? Do you have a business? Do you have a boat? Do you have an airplane? Who are your kids? And it's a way of ruling out the one Mike Jones against the other 2 Mike Jones. It's an identifying document. It is private. It is not recorded. It is only for our purposes, and we don't provide it to anyone other than our internal use to rule out liens that could be against a seller against a person that isn't our party. If it is our party, then we have to go and deal with the lien. If it's child support, a mechanics lien, a judgment. Unfortunately, someone named John Smith could have a lien, and if it's our person, we just go ahead and deal with it. Escrow would be talking to you about your seller's lien so that everybody is aware, so that we all know what we have to do to clear it. Next slide. You know, I'm going to go back to a couple other things back on that I don't see. This is a pretty generic prelim. I do a little more detailed one. The other thing I'd like to talk about is notices of abatement. And that is if the seller does something without permits and the county comes out and inspects and puts an abatement on it, that means that they have to go through the whole permitting process to clear that abatement and pay it in escrow. If you have, say, a garage, it's a pretty prime example of an abatement. We have to deal with the county on that. They typically have to pay some fines and fees, and they have to have an inspector come out and re-inspect and clear the abatement. Sometimes with an abatement, if you do something without a permit and the county doesn't like it, they're not going to sign off. They're going to make you take it down. We've also seen abatements for property condition if it's a fire hazard, if there's, I had one with cars, and he had a lot of cars and trailers and vehicles on the property that the county found to be a health hazard, and he had to remove them. So if you see an abatement or a notice of non-compliance, the city of Santa Rosa does a notice of non-compliance, the county does an abatement. We need to talk. I've talked a lot. Any questions? Anyone that I didn't answer your question?
I have a question. I had a seller one time where we got, or no, I was representing the buyer. We got in a contract and found out that the home, it was part of a program where the city had first right of refusal to purchase the property. Where, I mean, that would obviously come up on the prelim, right? Or is that?
Yes.
Yeah,
Yes.
where is that?
It would show up on a prelim in the exceptions, typically before the deed of trust. And we see those with, I've seen them with the county, the community development. Cloverdale had some self-help housing, Burbank housing, and those are often where they get down payment assistance, or they get silent seconds, or they get some kind of ownership assistance. And then that program gets the first right to buy the property. In that case, buyer and seller would have to go to whatever entity that is and go through their application process. Or I just had one in Sebastopol where the city opted out and the seller was able to sell the property, but they had to go to the city of Sebastopol and the Sonoma County Community Development Commission and get permission and have them relinquish their interest in the property first. It would show on a prelim, and it's something important to know. If there's any language around self-help or self-built or silent second, those are likely to have an option where whatever governmental agency that assisted that buyer into getting into the property wants to be able to pass it on to another affordable housing buyer.
Interesting. Yeah, this in particular was just the entire neighborhood. All
Yep.
the houses in it were part
Yep.
of it.
Cloverdale has one. I know of it.
You know,
Yeah.
that's something, you know, in that case, the city had like 30 or 60 days to make their decision. So that's a great reason for a prelim before going on the market, right? When would you, and of course you don't know that till you get the prelim. When would you suggest that when we are representing a seller, when should we request a title report before going on market? Is there times that we don't need one, or would you, what do you suggest in that?
I would suggest that you ask for information, and the time to get a prelim is when they ask them, hey, how did you buy this house? Did you get any kind of financial assistance? Did you get some state assistance, down payment assistance? Ask that question. Sometimes we'll know the subdivision too. You know, like I say, I know the ones in Cloverdale, so you just tell me the address and I go, oh yeah, that's one. But ask that question of your seller. Hey, how did you buy? What did you do when you bought? The other time to ask that question is, oh, grandma left me this house and I want to sell it. Okay, we need to see how grandma held title. We need to know whether they're going into probate. Mom just passed and we need to sell her house. Same circumstances. Let's, anytime where you're dealing with an estate, someone who is deceased, someone who's incapacitated. Mom's been put into a care facility and now we have to sell her house to continue her care. Mom, if she's incapacitated, can't sign and can't use a power of attorney. So those are times to let's start look and see how mom holds title.
Okay. Great. I just had, I have a seller right now who had several deeds with private parties that he had paid off, but they had never, taken them off title. So,
Yeah.
It's a bit of a process. So
yes, I have one now that we got the prelim, and there are a couple of old deeds of trust that should have been paid off of the previous refinance. It didn't. Luckily, it was a local business that I know well. And I said, hey, can you help me with this? But yes, it's good to ask, what do you owe? Who do you owe? How do you owe them? And good to get a look at it. Absolutely.
Okay, great. Thank you. Who else has questions? Leslie is a wealth of information about escrow and title.
Hi, Leslie. This is Patty Keyser.
Hi,
Just
Patty.
wanted to I just want to point out that one of the places that you can find out stuff right away is just looking at the tax records. And
Yes.
I had a property that I didn't realize what a lis pendens was. And they had bought a foreclosed property, and the people that sold it or that lost it had a court decision about it. But you can see some of that information in the in that tax record first. That gives you a first.
Yes, you can. You can also the Sonoma County records, Sonoma County Recorder's index is public information, and you can run the name. There's a way to run names to see what's recorded. The thing about a prelim is that it does help rule out things that are satisfied and are paid off. But yes, looking for abatements and lis pendens and foreclosure, it's always good. It's really important to ask questions. It's funny what people will and won't tell you. And sometimes you have to really drill down to get them. Now, tell me the real thing. Tell me what's really going on. I'm wondering if sometimes it's just asking, why are you selling?
Yeah, the more we ask, and if we get any little inkling, make sure to pre-open so that we can get that title report and deal with anything before we get into contract.
Right. And my thing about that, it's really rare that I've had a transaction that we absolutely couldn't close. There was one, lack of access, and the neighbor wouldn't give them an easement. But otherwise, we pretty much can close most everything. It's just timing and expectations. And it's funny how I hate to get up on my soapbox, but we're in a technology time where things are expected faster and instantly. And there are some things that take time, which is why I said what I said about bankruptcy. Sometimes it's not my decision on when we can close. It's up to somebody else, and their time frame is different from ours. And that's always important to keep in mind. Sure, you can write that contract and want to close in 7 days, but is that really reality? Can we really close in 7 days? It depends.
What is the shortest, or if, if there is an all cash purchase, is 7 days
That's because what if the seller has a payoff lender that's going to take 10 days to get us a demand? Again, something I have no control over. I'd love to close in 7 days, but if the lender's not going to give me a demand, or a homeowners association, they're also the ones that like to take forever. So yes, you could write 7 days, but if we're stuck waiting that's typically what would hold up the transaction, is waiting for another third party to get us enough information so that we can close.
Yeah, I've always done just minimum 10.
Yes.
Please
no 3 day. Yeah, no 3 day. No.
Great. Any other questions? Anybody have things they'd like burning things they want to know more about on the preliminary title?
Did we answer all of Curtis's questions? I wanted to make sure that.
I believe so, and I found some information with regards to endorsements. So I got Curtis's email as well as Alicia's. So we'll send that information to you guys.
Great.
Oh, looks like somebody raised their hand that was.
Curtis is saying yes, and again, thank you.
Good.
Our
good.
pleasure.
Thank you.
Looked like somebody raised their hand, but then it went away. Does anybody else have another question? You can just
Yeah, hi,
unmute.
hi.
Oh, hi, Gary.
Hey, how are you guys? Yeah, maybe you could just explain the distinction between the escrow officer and the title officer, because that sometimes
Yes,
we
great question.
need
The
to,
best question ever.
yeah, we need to get to the
Yeah.
title officer rather than the
Yeah.
escrow.
I'm not a title officer. I don't search the properties. I don't put out a prelim. I handle how to clear the exceptions. I handle the money. I handle the documents. The title officer does the research, decides whether an exception stays or goes, works out the correct legal description. They're on the production side of putting out the report. It's really rare that you're going to talk to a title officer unless you have a property that's really in depth and you might need some answers about what we show on our prelim. Then you would talk to the title officer. They're on the research side. They're searching the public records. They're looking at documents. They're determining whether a document stays or go. That's not me. I'm an escrow officer. What I'm doing is safeguarding funds and documents until such time we can close our transaction. I'm facilitating the signing. I'm taking deposits. I'm issuing payoffs. I'm handling commissions. I'm handling documents and money and signing, and I deal with the clients or the title officers in the back researching. Does that help?
Perfect. Perfect. I sort of think of it a little bit like a loan originator and the underwriter, right? The loan originator is the person that we're talking to, kind of the face, and then the underwriter is handling all the back end stuff.
That's exactly. And some of our title officers are underwriters because then they're making decisions on whether we're able to insure the property, and we refer to them as underwriters, and they do give, like, if you have a bankruptcy, I need underwriting approval. I need someone to look at this to say that we're ready to insure the transaction, and they have the title knowledge and the risk knowledge, because remember, we're an insurance company and we're assessing risk.
Very good point. I think we all forget that.
It gets lost sometimes because we get caught up in the transaction itself, but our main focus is issuing insurance.
Great. Thank you. All right. Well, if there is no other questions, we will let Leslie go. Just to let you all know that the team there at First American is available. Leslie's always there to answer questions. And then Lynette, Karen, and Madrona, they're the business development in and can help you. If you want to get a farm, they have some technology, I believe, that they can help you with and really provide a lot of support. Do you want to, Lynette, or one of you, just speak to that real quick? What's available if anyone wants to reach out?
Hi, Lynette again. So we do have multiple platforms and we are switching over. There was a quick slide on Ignite RE, which is going to be our new one platform where you would just have one username and password and sign in, and you can get to what used to be called Secure Portal, which will be called Transactions. And so that's where you'll communicate with your escrow officer in a secure format. And then there is My First AM is going to be called Properties. That's where you would look at that information. So you can do property searches. You can find out some good general information on that. And then Farming is our title toolbox, which it's an amazing platform. It has a lot of free farming information, very, you can even target market like empty nesters, you can next sellers, you can look at turnover ratios to kind of see if you're hitting an area that has a good turnover ratio. And then there's a layer of leads that you can purchase. So those would be phone numbers, emails, life events. So that is the second or an additional layer that you would have to put your credit card in and purchase that. We also have included in that platform is called Calculators. It's our what was cost first. You can get the title and escrow fees on for your clients and kind of give them an idea for your buyers or your sellers what that's going to look like. So it's a great platform, and we are just it's just rolling out now, so we'll be rolling over some people that already have some of our existing platforms into that. And it's gonna kind of happen over the next few months because it is a brand new way of us getting into all of those platforms that you guys have used before. And we are here and we love helping people. We love helping people with brainstorming on how to generate business and helping them with their farms, and also connecting you with an escrow officer that fits your style. We have amazing escrow officers in Sonoma County. We have 6 offices, 2 in Santa Rosa, 1 in Petaluma, 1 in Sonoma, 1 in Sebastopol, and 1 in Hillsburg. So we got you covered.
Great, thank you. And if you go out on tour, you'll often see Lynette, Karen, and Madrona. So keep an eye out and say hi to them. Garrett, did you have anything you wanna, since you were able to join us, anything you wanna jump in on?
No, great presentation. Thanks, first Am. And we'll carry on next week with contract training and some of our internal tech training.
All right. Thanks, Lynette and Leslie and Karen.
Yeah, thank you for having us.
All right, we'll see you all next week.
Okay, sounds great.
Mhm.